Good afternoon, friends. This is our 21st case law from the syllabus of Advocate on Record examination of the Supreme Court of India. Before exploring this and diving into this case law, I will request you all, if you find the videos valuable, please subscribe so that I am motivated to go further and dive further into the rest out syllabus of the Advocate on Record. So, with this request, I am going and driving through this important case law. The case law is SVP and Company versus Patel Engineering 2005. This is a landmark decision by the Honorable Supreme Court of India that deals with the scope of judicial intervention in the arbitration process and the power of the court under the Arbitration and Conciliation Act 1996, particularly with regard to the appointment of an arbitrator. So this whole case lies about the appointment of arbitrator. So before going further into the case, I will share with you the facts of the case. The dispute between SVP and Company and Patel Engineering Limited arose from a contract involving construction work. The agreement between the parties included an arbitration clause for resolving disputes. There is no doubt there was arbitration clause. When a dispute arose, SBP and Company approached the Chief Justice of India or his designate to appoint an arbitrator as provided in the arbitration agreement. However, Patel Engineering Limited objected to the appointment and challenged the arbitrator's appointment, claiming that the dispute is not arbitrable. So the case ultimately reached the Supreme Court, which had to determine the scope of judicial intervention in the appointment of an arbitrator and the power of the court in relation to such matters. So the key issues that arose in this whole case were whether the court had the authority to examine the issue of arbitrability before the appointment of an arbitrator, whether a party can challenge the appointment of an arbitrator under Section 11 of the Arbitration and Conciliation Act 1996 on the ground that dispute is not arbitrable. Third one was the extent of judicial intervention in the arbitration process under the Indian law. So, going through this whole arguments, the Honorable Supreme Court gave its ruling. The Supreme Court of India in this made some important observations regarding the role of the judiciary in the arbitration process under the Arbitration and Conciliation Act 1996. Firstly, it said judicial intervention before the appointment of arbitrator. On this point, it gave its ruling. The court held that judicial intervention can be sought under Section 11 of the Arbitration and Conciliation Act 1996 before the appointment of an arbitrator to decide whether the dispute is arbitrable. The Chief Justice or his designate can determine whether the dispute falls within the scope of the arbitration agreement and whether the arbitration clause is valid and enforceable. Second one, what it did, examination of the arbitrability. The court ruled that the question of whether a dispute is arbitrable, whether it is capable of being referred to arbitration, can be decided by the court before the appointment of an arbitrator. The court is allowed to examine whether the dispute falls within the ambit of the arbitration clause and whether it is capable of resolution through arbitration. Then it discussed the scope of Section 11. Honorable Court clarified that the appointment of an arbitration under Section 11 is not a mechanical process, and the Chief Justice or his designate has the discretion to examine the validity and enforceability of the arbitration agreement. The court emphasized that the court's role in the appointment of an arbitration is not limited to merely confirming the existence of arbitration agreement, but to also extends to that the dispute is indeed arbitrable. Then it said there should be minimal judicial intervention. The Honorable Supreme Court reasserted the principle that arbitration is a private dispute resolution mechanism and the judicial intervention should be minimal. However, the court also recognized that judicial authority is required to ensure that dispute is suitable for arbitration and that the arbitration agreement is enforceable. So, the key results from the judgment, or we can say the key takeover from this judgment are firstly, arbitrability determination. The judgment says go to the arbitrability determination. The judgment clarified that the issue of arbitrability is within the scope of the judicial scrutiny before the appointment of an arbitrator. This means that the court can assess whether the matter in dispute is something that can be adjudicated through arbitration. Second one was power of the Chief Justice or his designate. The Chief Justice or his designate has the power, sorry, the Chief Justice or his designate has the power to decide whether the dispute is arbitrable and whether the arbitration agreement is valid. This is not a mere formality, but a substantive role to ensure the proper functioning of the arbitration process. Third one was limited judicial intervention. While the court held that the judicial authority can intervene in the appointment of an arbitrator, it is also the principle that the judicial intervention in arbitration matters should be minimal and limited to specific circumstances, such as examining the validity of the arbitration agreement or deciding on the arbitrability of the dispute. So, nutshell impact of the case is the SBP and Company versus Patel Engineering Limited judgment was significant in defining the role of Indian courts in the arbitration process, particularly in the context of the appointment of arbitrators. It strengthened the importance of judicial review at the initial stage of the arbitration process, ensuring that disputes referred to arbitration are appropriate for such a resolution mechanism. This case also clarified the boundary of judicial intervention, promoting the idea of minimal court interference in the arbitration process and ensuring that arbitration remains an effective and efficient alternative dispute resolution mechanism. So this was all about this case. Next time I will go through 22nd syllabus of the advocate on record examination. Till that, good night, have a good day.